Welcome to the video, Texas Transfer and Death Deeds, Information and Answers. This video is a general guide and may not apply to your individual case. This video is not a substitute for legal advice. If you have questions, please consult a lawyer or visit www.texaslawhelp.org. Question 1. What is a transfer on death deed? As of September 1st, 2015, Texas law allows a person to transfer their ownership rights to real property located in Texas to a named beneficiary or beneficiaries without a will. This is done by using a document called a transfer on death deed, also known as a TOD. TODs are a simpler and more cost-effective way to give real property such as your house or land to someone when you die. TODs can only be used towards real property and not personal property such as cars or jewelry. The TOD does not take effect until you die. For example, you can still sell your house or get a loan with your house as collateral. The TOD does not affect any creditor claims on the property. You can still use a TOD if you have a mortgage or lien on the property, but your beneficiary will be given the property along with those debts when you die. Lastly, as of now, properties transferred through TODs are not subject to Medicaid estate recovery. Question 2. What if I have a will? If you also have a will, a TOD will trump the provision of the will related to the specific real property. This means whoever you name in the TOD will receive your property after you die, not the person named in your will. Question 3. What if I'm married? If the real property to be given is community property, your TOD will only affect your share of the property and not your spouse's unless they file a separate TOD. Question 4. How do I get a transfer on death deed? A person filing a TOD can name whomever they want as a beneficiary. They can also name multiple beneficiaries and alternates. The beneficiary does not have to sign the TOD, nor does he even have to be notified. He does not have any control over the property until you die. The TOD becomes effective when it is filed with the county clerk's office where the property is located. It must be filed prior to your death. Question 5. Can I cancel my transfer on death deed? Yes, you can file a cancellation prior to your death. Your cancellation will only affect your share of the property if there are other owners. Question 6. After I die, how does my beneficiary get ownership of my property? After your death, your named beneficiary must file a form called an affidavit of death with the county clerk's office where the TOD is filed. Later, if the beneficiary would like to sell the property or take out a loan, he will need to provide proof of the death, such as a death certificate, to the title company. If you have any other questions, contact a live help specialist on texaslawhelp.org. This video has been produced by the Texas Legal Services Center and funded by the Texas Access to Justice Foundation. Thank you for watching.